Hello, my name is Mike Geiermann. For the last 35 years, I've had the privilege of representing public school teachers, public employees, and higher education members of the North Dakota Education Association and North Dakota United. Recently, I've been asked to provide you with information regarding a topic that's been around for a long time, and that's the topic of sexual harassment. The purpose of this seminar is to give you a roadmap in regards to sexual harassment, what sexual harassment is, and more importantly, what it's not. The laws behind it, its origin, some case examples, so that you will be better informed about what sexual harassment is all about. We want to provide you with resources in the event that you believe you are a target of sexual harassment or you believe a colleague is a target of sexual harassment. But by far and away, the most important piece of information I can give you is to call NDU. If you believe that you are the victim of sexual harassment or one of your colleagues is the victim of sexual harassment, I would encourage you to call North Dakota United. Tell them what's going on in your workplace, get some advice from them, and see if we can address the issues that challenge a lot of the workers in the state of North Dakota. So as the seminar goes on, I will be providing you with information in regards to the law, and once again, some case examples about sexual harassment, and then hopefully we will get some contact from you so we can answer your questions. One of the main questions that we're asked is, what are the origins of the laws prohibiting sexual harassment? There are both federal laws and there are state laws that deal with this issue. On the federal side, the main law is what is referred to as Title VII of the Civil Rights Act. Specifically, Section 703 of the Civil Rights Act provides as follows. It shall be an unlawful employment practice for an employer to fail or refuse to hire or discharge an individual or otherwise to discriminate against any individual with respect to compensation, terms and conditions of employment because of sex. Now, Title VII also provides prohibitions against other issues in regards to race and color and religion and national origin. But today we're just going to focus on the discrimination based upon sex. In addition to Title VII, there is also what is called Title IX of the 1972 Education Amendments to the Civil Rights Act. Title IX is familiar to a lot of people because Title IX was the federal law that ensured equal opportunities for boys and girls, men and women in athletics. Title IX, for our purposes today, only deals with discrimination which is brought by students against school districts when it involves sexual harassment. So we won't spend too much time on that today. Another law that deals with the prohibition against sexual harassment in the workplace is under North Dakota law. It's part of what's called the North Dakota Human Rights Act. And that's found at North Dakota Century Code Section 14-02.4-03. And like Title VII of the Civil Rights Act, this section of the North Dakota Human Rights Act prohibits discrimination in the workplace based upon sex. So while there are all of these laws in place to prohibit sexual harassment, it still happens. And what I'd like to do is now outline a couple of the cases which have been decided both by the United States Supreme Court and the North Dakota Supreme Court in regards to these claims. As far as a reference goes, that you could look up a lot of this information. There's the old saying about you can look up something on the internet and you can find everything that you want on the internet. And when it comes to sexual harassment, that's true. But if you want a very, very good starting place for looking up information about sexual harassment, I would refer you to the EEOC website. The EEOC website is the Equal Employment Opportunities Commission. It's a federal agency. And they have a website, and we're going to put up that website so that you can see it. If you go to that website, you're going to see all sorts of information in regards to sexual harassment. And it will put you on the right track to getting a better understanding of what sexual harassment is, and just as importantly, what sexual harassment is not. If you've taken my advice and you've gone to the EEO website, you're going to come upon a site to the definition given to sexual harassment by the EEOC itself. That site is found at 29 CFR. CFR simply stands for Code of Federal Regulations. It's in section 1604.11. And as defined by the EEOC, sexual harassment is harassment based on sex, which includes unwelcome sexual advances, requests for sexual favors, or verbal or physical conduct of a sexual nature which constitutes sexual harassment when submission to such conduct is made explicitly or implicitly a term or condition of an individual's employment. Now that's a long drawn out definition. So oftentimes what happens is it's almost sometimes better to go to some of the case law that is been developed by the United States Supreme Court and the North Dakota Supreme Court in regards to sexual harassment. The premier case which established recognition of sexual harassment for purposes of federal law is a case called Maritor Savings Bank versus Vinson. And it was decided in 1986. Michelle Vinson was a teller at Maritor Savings Bank. And through the course of about 4 years, the bank manager subjected her to what we refer to as quid pro quo sexual harassment. Ms. Vinson, at the trial of this case, testified that between 40 and 50 times, the bank manager forced her to have sex. He would fondle her, he would expose himself to her, and he did other things in a very sexual manner in exchange for allowing Ms. Vinson to remain employed at the bank. Well, she was promoted based upon her merit. She was subjected to the classic quid pro quo sexual harassment. And quid pro quo is simply the word which means if I give you something, you'll give me something in return. That's basically what quid pro quo stands for. And that's the harassment which requires your continued employment or advancement or promotions based upon the provision of sexual favors. In the 35 years that I've represented NDEA and North Dakota United members, I have never come across a specific case dealing with a quid pro quo type of sexual harassment. That doesn't mean it doesn't happen. I'm sure it does happen. It simply hasn't been reported to us so that we could deal with it. But that's the first case. It's quid pro quo. It's basically you're being required to keep your job or to advance in your job, the provision of sexual favors to a boss, and that was outlined in the case of Maritor Savings Bank versus Vinson. The second type of sexual harassment, which is prevalent in certain employment areas, is what is referred to as the hostile work environment. The hostile work environment is actually a type of sexual harassment which was recognized also in the Maritor Savings Bank versus Vinson case. I think of all the terms involving sexual harassment, the term hostile work environment has been watered down and has lost some of its original meaning. I have talked to many employees, both members of our association and outside, who believe they have been subjected to a hostile work environment. Most oftentimes in that scenario, they're getting a hard time from their boss. Their boss is yelling at them and is screaming at them and is requiring them to do certain tasks that may not fit well within their job duties. And so immediately they come to the conclusion that I am being subjected to a hostile work environment. But the term hostile work environment has a very specific legal definition to it. And the other thing that gets lost in the application of hostile work environment is that when you're talking about it, and we'll define it in a minute, when you're talking about hostile work environment, it still has to involve discrimination based upon your gender. That you are the subject of this attention or abuse or yelling or screaming simply because of your gender. The other thing that gets lost in regards to hostile work environment is it doesn't necessarily require sex or sexual desire. Sexual harassment, for lack of a better term, is based upon power. It's based upon authority. It doesn't always have to deal with sex or sexual favors. And so in the situation that you may find yourself in, where you are getting the hard time from your boss and those kinds of things, it may not have anything to do with sex. It may not have anything to do with sexual advances or sexual desire, but it has to do with power. And I want to make sure that you understand that so that you don't get all caught up in the fact that, well, he may not want to have me perform sexual acts on him or things like that, but it still can be sexual harassment. When the Supreme Court in the Maritor Savings Bank versus Vinson case defined the term hostile work environment, what they said was that such conduct is actionable if the harassment is unusually severe or pervasive, to alter the conditions of a victim's employment and to create an abusive working environment. The correct inquiry in regards to a hostile work environment is whether the victim, by her conduct, indicated that the alleged sexual advances were unwelcome, not whether her actual participation in the sexual intercourse was voluntary. So let's cut that up a little bit. Let's divide that out. One of the things that you have to make sure you understand about sexual harassment is the advancements or the conduct that you believe constitutes a hostile work environment is unwelcome. Okay, you don't want this to happen. It doesn't mean you have to tell them to stop. Most of the time, you should tell them to stop. And in this day and age, I think what I've seen, the evolution of this issue is most oftentimes the victim of these things will tell the other person to stop. But the law doesn't require you to stop. So there are three things that you have to keep in mind when you're talking about a hostile work environment. The first one is that the advancements or the conduct that's being directed your way is unwelcome. The second one is that it is pervasive. It means it happens a lot. It happens not every day, but it happens a lot. And that it has to be severe. And those things, the combination of those three things, unwelcome, pervasive, and severe, have to alter your employment, where you don't want to go to work anymore, or where you're avoiding certain people in your office because they treat you this way. That's when it becomes unwelcome and pervasive and severe. Now, the Supreme Court is also clear that a one-time incident of sexual harassment, the telling of a dirty joke, the offhanded comment by a colleague as to how you look or what you've got on, a one-time occurrence like that is not in and of itself going to be sexual harassment. It's got to be pervasive. It's got to be often. It has to be frequent to reach a level of actionable sexual harassment. So the fact that you're getting a hard time from your boss in and of itself doesn't meet the standard. It's got to meet those three standards. The other part of it is this, is when I talk to employees and members of NDU about these kinds of issues, one of the first things that I ask them about is this manager, is this supervisor, is this principal, superintendent, whoever happens to be, do they just treat you like this? Or do they treat everybody like this? If the answer is they treat everybody like this, if they treat the men this way and the women this way and the secretaries this way and the teachers this way and the administrative personnel this way, if they treat everybody that way, then it's not sexual harassment. They're just bad managers. And under the law, they have the right to be bad managers. But if the question is no, they just treat me this way, I'm the only one who gets treated this way, nobody else in the office gets treated as badly as I do, then it might be sexual harassment. then you need to pick up the phone and call us. Another thing I want you to keep in mind about sexual harassment is it just isn't male to female anymore, and it hasn't been for quite a while. Back in 1998, the United States Supreme Court decided a case called Oncali versus Sundowner Offshore Services, Inc. Oncali was in the middle of the Gulf of Mexico on an oil rig. It was an all-male crew. And between some fairly blatant sexual acts they attempted on him and the fact that they called him names and all the rest of it, when Oncali couldn't take it after a long period of time being out on the oil rig, he ended up resigning. But when he resigned, he asked his bosses to put in there that he had been sexually harassed. So Oncali brings a case in federal court for the first time where an individual alleged that they were being sexually harassed by members of their own gender. So this was male on male sexual harassment. It gets to the United States Supreme Court, and in a unanimous decision, the United States Supreme Court issues an opinion recognizing for the first time the same-sex sexual harassment, that Oncali did have a sexual harassment claim against Sundowner, even though the only people that harassed him were of the same gender. Oncali therefore recognizes that there can be male-to-male sexual harassment and there can be female-to-female sexual harassment. But when Judge Scalia wrote the opinion for the United States Supreme Court, he also indicated that Title VII is not a code, is not a general civility code. In other words, the law doesn't require you to behave yourself. What the law prohibits is a scenario where you are being discriminated against because of your gender. Justice Scalia said the objective severity of the harassment should be judged from the perspective of a reasonable person in the plaintiff's position, considering all the circumstances. He also believed that common sense should prevail in these kinds of cases. The other thing that's interesting about the Oncali case is Judge Clarence Thomas's one-line concurring opinion, in which he said, "I concur because the court stresses that every sexual harassment case, the plaintiff must plead and ultimately prove Title VII statutory requirement that there be discrimination because of sex." This reinforces the concept that just because you're getting a hard time from your boss, or your boss disagrees with you, or sometimes he is angry with you, or he yells at you or whatever, doesn't mean that you're being subject to a hostile work environment. We've got to tie all of those allegations, once again, the unwelcomeness of it, the severity of it, and the pervasiveness of it, back to your gender, whether you're male or female, and then you may potentially have a sexual harassment case. But more importantly than anything, when in doubt, and I can't stress that to you enough, when in doubt, pick up the phone, call us, call NDU, call your field representatives, tell them what's going on in your workplace. You don't need to endure this. Those days are gone. If you believe that this is actionable, we will try to assist you in every way we can to rectify the situation so you can simply go to your job and do the great job that you have in the past for all of the people of the state of North Dakota. Thank you.